The Texas Penal Code establishes criminal liability for corporations or associations. It's important to note that we most often see corporations and associations prosecuted under federal law, but provisions exist for them to be prosecuted under state law as well. The Texas Penal Code states a corporation, association, limited liability company, or other business entity is criminally responsible for an agent who commits a felony while acting in behalf of the corporation or association, acting within the scope of their employment, if the penal code or other code specifically indicates the corporation or association has a responsibility or where strict liability is imposed. Strict liability is liability that does not depend upon actual negligence or the intent to harm, but that is based on an absolute duty to make something safe. It most often applies either to extremely hazardous activities or in product liability cases. Strict liability is specifically indicated in written law. The Penal Code goes on to state a corporation, association, limited liability company, or other business entity is criminally responsible for a felony offense only if it was authorized, requested, commanded, performed, or recklessly tolerated by a majority of the governing board or a high managerial agent acting within the scope of office or employment. Finally, a person acting in the name of a corporation, association, limited liability company, or other business entity is responsible for a criminal act as if he was doing it on his own and is responsible for any criminal omission as if he was doing it on his own. The sentence imposed is served by the person, not the corporation, association, limited liability company, or other business entity. In other words, there are no team penalties or bench penalties for a person acting in the name of a corporation or association. The person who committed the offense on behalf of the corporation or association is the one that will go to prison.